Morning. This is case number 2023-0615, Caroline Adams et al. Versus Moose Hill Orchards LLC, DBA Max Apples. Attorney Zimmerman, I understand you reserved 2 minutes for rebuttal.
Yes, sir.
Please proceed.
Now, in your brief, you argue that you should have been allowed to engage in some discovery. What facts would you seek to uncover that would address the immunity statute?
Well, I think one of the questions the court has to answer is what is the scope of the meeting without charge within 508.14? Because if the question is it literally just was there a charge for using the sledding hill, then there wasn't, and we're not disagreeing. But there's a lot of the cases talk about, if you look at Sorahan versus Mount Cranmore, even if you look at Hardy, the cases talk about whether or not there's a business connection, which is a long way to getting to the point where I would say that part of the question is, what is the benefit Max Apples is getting from this use, this sledding? If Max Apples is benefiting financially, they're getting their winter sales predominantly from the sledding hill, they're selling hot cider.
So, but if they operate as a loss, then the immunity applies? So, for example, they don't make enough money to pay the employee. Under that situation, the statute would apply?
So that's an interesting question that I have not considered before, but I think the bigger question is it related to their business purpose? Whether or not they're a successful business initially, whether or not it grows. I don't think it's the profit and loss. I think it's whether or not there's a business purpose.
Well, if there's a business purpose, there could be a business purpose if there were no charging for anything and they just gave out a certificate to come back next summer and buy apples. So they would be giving them something, not asking anybody to pay, and that would be a business relationship. Would you argue that that's enough?
I think the test should be whether or not there's a financial interest. If you're using that as advertising to bring people back in the summer and I think it's a question of what is it? Here, you can come back and we're going to give you 2 free apples if you come in August. But the discovery shows the reason they started that program is because they want people to come to the farm stand and buy their product, sell their product.
Discovery, this is on a motion to dismiss.
Correct.
And you're not disputing this presents anything but a pure question of law.
It does represent a pure question of law. And following up primarily on the question of what would we want to do with discovery. Because on a motion to dismiss, as the court knows, wow, I just got much louder. Sorry about that. On a motion to dismiss, as the court is aware, you're looking at the pleadings and whether or not the pleadings state a factual basis to proceed. And on the pleadings, we have alleged that the sledding hill is akin basically to an advertising source. This is what's bringing customers in.
Paragraph 13 also alleges that there's no charge for using the sledding hill.
There was not a specific charge for
And
using the sledding hill.
statute says without charge. So how do we reconcile that?
So I'd like to discuss a little bit the estate of Jacob Gordon Kocher versus Brown for the answer to that question. Because in that case, the statute also says that immunity applies to any person coming onto the property. And this court looked at that language, any person, and said that if read literally and in isolation, this would give immunity to any person using land without a charge, nullifying the laws of premises liability. And because this is a statute that is in derogation of the common law, taking away the right to bring a lawsuit for these types of injuries, it needs to be strictly construed. limited as narrowly as possible, and read really in context of the purpose of the statute. And I think a strict interpretation of RSA 50814 along those lines should include looking at the charge, not necessarily being, did I ask you for $10 so you can come use my sledding hill, but the bigger picture of, is there a financial benefit? And this is somewhat consistent with some of the cases, this is consistent with the cases this court has decided. This court in Sorahan looked at Hardy versus Loon Mountain and held that, and looked and said, for example, that it's only fair that when businesses profit from recreational access, they would be subject to liability for their negligent actions.
But didn't Hardy arguably include the profit to Loon Mountain by charging for the use of the gondola?
So that was the question that the First Circuit looked at in Hardy. And what I don't know, and yes, the gondola was argued as the charge. We did not look at, or the court did not really explore a lot whether or not there was other financial benefit to Loon, but in the end said this was not related to Loon's primary purpose of running a ski area. And I would argue that in this case, the use of the sledding hill, the bringing of individuals into this is related to the primary purpose of Max Apples, which is to sell goods at their farm stand. This court, looking at the Hardy case, in the Sorahan decision, said Loon Mountain was required to allow visitors to hike and sightsee in the area without paying a fee. Accordingly, the summer recreational activities offered at Loon Mountain are not related to its business of operating a ski area and are open to the general public without charge.
So is the key how you define the primary purpose of the host?
I think that is a primary key, yes, because if you look at some of the other cases where recreational immunity was upheld, for example, the Cantor versus Combustion Engineering and Fish versus Homestead Woolen Mills, those both involved cases where individuals were swimming. But the swimming had absolutely no connection, no business profit, no link to the individuals who own the dams, who own the water, who were running unrelated businesses.
So where's the link between the sledding and Max Apple Farm?
So my clients would testify, and we've said in the pleadings, that in part what brought them there was that they understood that they were selling hot beverages, that this was a place they could go and sled and enjoy the benefits of Max Apples. The trial court used the example of, look, there's not a charge for the hot chocolate, I think was what the trial court used as an example. Saying, look, if I pay $3 for a hot chocolate and I get a hot chocolate, my charge is for the hot chocolate, not for this other stuff that I got to do, that being the sledding. But I can go anywhere to buy hot chocolate. I could go to Starbucks to buy my hot chocolate. I could go to Dunkin' Donuts to buy hot chocolate. If people are choosing to come to Max Apples, because Max Apples is providing these services, providing this food, providing these sales, and using their sledding hill to attract those customers, it's more akin to, I think one of the examples I gave in the brief was a outdoor play area at a mall. If you have a commercial business that is running a mall and decides that one of the amenities it wants to offer is a play area,
But a mall's not land. The statute applies to land, doesn't it?
So there are outdoor malls. There are malls that have outdoor playgrounds, and this court has said it's not just land, because in the Dolbear versus Laconia case, you all found that the use of a playground in that case in the city of Laconia was covered by 50814.
You mentioned in terms of strictly constructing the statute that we need to consider the purpose of the statute.
Yeah.
And do you agree that the purpose of the statute is to encourage private landowners to make their lands available for recreational use?
I agree with that.
So how does your interpretation advance that purpose?
Because in this case, they're making the land available for recreational use for their own benefit. It's not an altruistic, we're making this available to public. It's the equivalent of that playground at an outdoor mall.
It seems to me you'd be making the same argument whether or not they had hot chocolate there or not, or whether they charge for the hot chocolate or not.
I think I would be
it draws people to a place where someday somebody might buy some apples.
Well, you're parking in their parking lot, you're walking by their store, you're going behind their store to then sled on their hill. I think there's a more direct nexus than hoping someone might buy something. But I don't think the case necessarily hinges on whether or not there was hot chocolate outside available that day or not.
Or whether they were charging for it or not?
I think whether they're charging for it absolutely matters.
So if they were giving it away, then you wouldn't have an argument.
I think if they were giving it away, my argument would be that we should be able to do some discovery to determine what other benefits they're getting from that. Because again, you have many businesses that might do some sort of free giveaway to entice something else. So and I don't know what the evidence would show because we weren't given the opportunity to proceed with any discovery. But for example, are their profits significantly higher as soon as the hill is covered with sledding? Is available for sledding. Do we have a drop in early December, a pickup over Christmas, a drop in January, and then the sledding hill becomes available, January 20th on, and for the next month and a half, is there a upward spike in their winter revenue? I think those are the types of questions that need to be asked. Because again, if it's being used to draw people in for business, this is not the same as a landowner altruistically saying, of course people can go use my hill. This is a landowner who's benefiting from that use in a direct financial way. And while it may not be a kind of quid pro quo charge, pay me $10 to use the hill, within the meaning of the statute and within the intent and scope of premises liability law, we would be discarding a lot of that if the court said, it doesn't matter if there's a business purpose. It doesn't matter if there's a profit. It doesn't matter if they're using this to entice people to their business.
Arguably, if they rented sleds, tubes, that would not have a direct connection to the use of the land, but it certainly would be a draw and a connection to their business.
Correct.
Isn't that so?
Yes,
Not much different than the hot chocolate.
correct. I mean, from our perspective, it's being used as for an advertising purpose, directly related to the business.
Well, you allege that you found this opportunity online. Does Max actually advertise their sledding hill?
So I believe that's probably moving beyond the scope of the pleadings that the court has to decide on. So but I will say that I have seen references to sledding at Max Apples. My clients saw them online. I think they read an article that was put forward by someone else. And we have not, again, because we haven't been able to do discovery, find out if Max Apples, for example, for their mailing list, what they send out. Do they send out notices that the sledding hill is now available and open? Don't they? We don't know that because we were shut down before any discovery was conducted. But that would be one of the questions.
How significant is the history of the property? In other words, if it truly was an apple orchard that maybe evolved and people were sledding there simultaneously, how relevant or meaningful is it that now there's a farm stand and the use has adapted with time?
Well, it's a farm stand that's still open in the middle of the winter. Well, the sledding hill is there. And I would posit that there's not a lot of people who are going and buying apples from farm stands necessarily in the middle of January.
But it isn't the primary purpose that this is an apple orchard and the farm stand is maybe a corollary to that?
I think in the summer that might be the argument, but in the winter I'm not aware of anything that's going on other than the farm stand. There's pumpkins in the fall, and then we have winter, but during, when we're looking at December, January, well, other than maybe Christmas, but, January, February, those areas, the farm stand is the primary use of the land at that time.
Thank you very much, Attorney Zimmerman. You reserve 2 minutes for rebuttal. Attorney Wright?
Thank you.
Good morning. May it please the court, I'd like to start off by noting something that is obvious, and that words have meanings, and those meanings are important. Those meanings allow for us to have a consistent understanding of what we, either as individuals or as a society, are trying to convey. The words we use in our statutes were selected by our legislators to have meaning because they express the intent of the statute. And the specific statute at issue here is RSA 508-14, entitled Landowner Liability Limited. Its very title shows the legislature's intent. And very briefly, and for our audience, that pertinent part reads, "An owner, occupant, or lessee of land, including the state or any political subdivision, who, without charge, permits any person to use land for recreational purposes as a spectator for recreational activity shall not be liable for personal injury or property damage." The language and the meaning of that statute is plain on its face. If a landowner makes this land open to the public for recreational use without a fee, they cannot be held liable for injuries.
Would that also apply to like an attractive nuisance? For example, I noticed that there's a ski jump in the backyard of our host here today. If Justice Bassett decided to enter the land, use that without a charge, and then injures himself, would the school or the town be liable?
I think you're actually now going into the scope of RSA 21234, which covers outdoor structures and does provide immunity in those situations. So I do not think the school will be liable for injury that happened on a ski slope like that. But it is, as I was saying, a quid pro quo. The citizens of New Hampshire get access to private land for free for recreational use, and in return, they give up the right to sue if they're injured on that property.
Do you agree that the statute needs to be strictly construed?
Yes, it does. It's a derogation of common law. But you can strictly construe the statute and still find that my client is not going to be liable for injuries. In fact, that is the intent of the statute.
What is the limit to the invitation extended by the owner of the land? How far can they go advertising or creating a situation that makes it more attractive for people to go, marketing it, selling things in connection with the use of the land? Where do we draw that line?
I think they can do all of those things. The key factor is they not charge for the use. And that's what this court has found consistently in other cases, and our federal courts especially have found in the cases, that the interrelationship between the land and the fee is the key as to whether or not the immunity pertains. In fact, this
So
court...
you can charge for all the surrounding activities, rent skis, rent boots, sell food, you can do all kinds of commercial activity as long as you aren't charging directly for use of the land.
That's it precisely. There has to be an interrelationship between the use of the land and the fee, and that was what this court noted in Cantner versus Combustion Engineering. Court noted consideration must be paid to create access to the land for the immunity not to apply. And the obverse of that is if no consideration is paid to access the land, then the immunity applies.
What if the plaintiff got hurt picking apples, fell off a ladder?
Well, there's another part of the statute that applies when you're on pick your own premises. There's no liability there as well. So it was a part of the statute that was argued in the underlying case, but not part of the appeal. But yes, there would be no liability.
You argued RSA 212 below. Can you just discuss the interplay of that and 508?
Sure. Both of them are land use immunity statutes, and they were created, I think, 508.14 was 1975, and RSA 212.34 was 1961. And they were promulgated because the legislature had a concern that private land would not be available for recreational use. So in order to foster recreational use without a fee from private landowners, they provided immunity for the use of that land to those landowners. 212.34 is actually, in my opinion, a little bit broader than 508.14. And given the situation of the playgrounds that you're discussing, if this court determined that, well, okay, we're going to say that 508.14 doesn't apply to the inside playground or the axe throwing, we would be back here in a year arguing whether or not 212.34 applies, because that has much more specific language as to outdoor recreational activities being immune from that, and actual structures on property being immune from suit if someone's injured on a structure. And the cases this court has decided is, one is a playground, the other was a rope swing going out over a lake where someone got their foot caught in it and was injured there. So they are intended to be read consistently so that you can't decide immunity doesn't apply in this one, but we'll give you immunity on this one. They're sister statutes.
Attorney Zimmerman argues that it matters what the intention of the owner is and what the purpose of opening the sled hill is in terms of whether they were trying to drive business or attract business. Does the mindset or the purpose of the owner, in your view, enter into the legal analysis?
No. The key element is whether they charge a fee to access the recreational use.
So if they are doing it so that they can make a lot of money every day, that people show up and go on the sledding hill, that's irrelevant.
It is irrelevant. The key has to be, the fee has to be charged for the recreational use. And the federal court heard a case very similar to this one, the Reed versus National Council of Boy Scouts. Some Boy Scouts from Massachusetts came up to a retreat in New Hampshire. They stayed in some cabins on this property. This property also had a sledding hill. The Boy Scouts went sledding. One of them was injured, and they filed suit. And they said, well, we had to pay a fee to stay in the cabins, so the immunity doesn't apply. But the federal court said, no, that's not what is important. That sledding hill was open to the public for free. You may choose to stay in the cabins, and that's an optional fee, but no one ever was charged for using the sledding hill. So as long as there's no charge associated with the recreational use, the liability is limited.
So if your client charged $50 to park in the parking lot before you gained access to the hill, you'd make the same argument.
No, I don't think that's a much closer call. If they're charging you access to the parking lot for the purpose of sledding, that might be a different case. That can be argued that the charge was associated with the use, recreation use of the land. But that's not the case here. There was no charge to use a parking lot.
Then how do you distinguish Sargon under your analysis?
Sorgan, Mount Cranmore is in the business of selling recreational use.
But
It's a ski
the
slope.
injured person didn't pay to be there.
And this court said that didn't matter. It was a matter that the recreational use, Mount Cranmore was something that was regularly charged for. If it's not that person, it was the daughter of the person who was injured, who was in a ski meet that day, and they actually had to rent the ski hill itself. So there was actually a fee associated with that recreational use.
The words of the Hardy Court. In the words of the Hardy Court, how is the defendant not directly profiting from the use of this land?
They're not directly profiting from, you mean the holding of the Hardy?
Yeah.
Well,
I mean, that's the term that Hardy used.
Yeah.
I mean,
Hardy is interesting in that he actually, the person who was injured actually paid some money to take the gondola up to the top of the mountain, and then he was injured. But the First Circuit said, well, that's not important, or that's not relevant, because he could still access the land without paying a fee. He chose to ride up in the gondola and pay that $5, I believe it was, but he wasn't required to do that. So since it was not a mandated fee for the use of the recreational use of the land, the immunity applied.
The statute was amended following this incident to address voluntary payments or contributions, which shifts the focus a bit to deal with these incidental payments. Do you know what the motivating factor was for that?
I do not know what the legislative intent was in promulgating those changes, but certainly as it stands right now, under the case law of this state, there has to be a direct fee for the recreational use for the immunity not to apply, and that is not what was happening here. The land was held open without a fee for recreational use. I mean, Moose Hill Orchards, it's an apple orchard. They make their profit from growing and selling apples. They make no money from sledding. They don't charge for it. The land is there to be used for free, so the immunity should apply. And that's what the intent of the legislature was, to keep this land open for us to use. And the court to construe that the immunity does not apply in a case like this, it could have a chilling effect on private landowners keeping their property open for recreational use without a fee. And just going back to Reed versus National Council of Boy Scouts, that was a case where there was a sledding hill, just like there's a sledding hill in this case. There was a fee charge for cabins, but the court held that even though there was a fee for the cabins, the sledding was free, and therefore there was no, there was immunity in that situation. Like the case we have here.
Doesn't that seem to invite some workarounds, if you will? My land's open, but I can charge for everything else associated with it.
As long as the land is open, the immunity applies.
So it wouldn't matter if there is direct profit arising from attracting people to the land.
So long as that direct profit was not derived for charging for the recreational use. That is the key with respect to the cases that have been argued and the statute itself and the meaning and intent of the legislature in enacting this statute. It is to keep that land open for recreational use. And it's important that the court understand the word land. It is not commercially developed property, it's land. This case this court in the state of Gordon Kuchar defined land as forests and farmlands. I cited in my brief Black's Law Dictionary as to the meaning of land in the most general sense, comprehends any ground, soil, earth whatsoever, including fields, meadows, pastures, woods, moors, waters, marshes, and rock. That does not contemplate commercial property. That contemplates land, raw and undeveloped land, and that's what this statute is supposed to apply to. It's not going to apply to somewhere where you're throwing axes, or the playground in the mall, or the ball pit at McDonald's. Those are developed properties, and general common law negligence would apply if there was an injury associated with those
How
particular
does that
venues.
fit with the gondola case, though? Because you don't have to use the gondola to assess the lower level of the land, but you may need to use the gondola to access the upper level of the land.
Well, I don't know, it depends how good of a hiker you are, I guess.
Exactly.
The thing is, you're allowed to use that land without a fee. That's the key part. Now, there's a gondola there, and it might make it easier for you to
Yeah.
get to the top, but that's optional. You're not required to use it. You can choose to use it, but that doesn't mean the immunity is going to go away because you've paid an optional fee. It was not mandated. So too, in this case, there was no fee for sledding. If indeed they had a farm stand, which my client vigorously disagrees with, but at this juncture, we take the facts as a plaintiff has pled them. If he were selling hot chocolate, hot cider, or something like that, it would be not relevant to the charge for the hill. In other words, that is not associated even with the sledding hill. You don't have to get a beverage to use a sledding hill. You can come walk right by the farm stand, go use a sledding hill. There's no fee associated with it. It was free and open for the public to use without a fee.
Still, under your argument, even if your client charged a fee associated with getting a sled, that would apply, and you'd still be immune.
Yeah, yes, they would. You could bring your own sled. Purchasing or renting a sled would be optional. If my client said, you have to use my sled, you have to purchase my sled to use a sledding hill, that's a different scenario. In that case, that fee would apply because it was mandatory. But any time it's not mandatory, it's not required for the use of the land, then the immunity applies. It's that interrelationship that is key. Is the fee charge related to the use of the land? If it is, there's no immunity. If it's not, no fee for use of the land, then the immunity applies and the landowner's immune from suit.
You mentioned earlier that 508 and 212 are related.
21234, yes.
Should we be consulting 21234 with respect to what charge means?
Well, they go hand in hand. They really do. I actually argued both of them in the underlying matter, and I thought the argument under 21234 was even stronger. But they should be read in concert with these charges to be consistent with their holdings. And that one does provide, I think, broader immunity than 50814.
If we were to reverse the trial court on 50814, should we go ahead and undertake the analysis under 21234, or would we send it back to the trial court for the trial court to do that?
You could if you decided to turn it back onto 21234, but we would probably be back up here again arguing the applicability of 21234, depending on what the underlying decision was with the court. And that, I'm just looking at 21234 in front of me right now. It says, a landowner owes no duty of care to keep the premises safe for entry or use by others for outdoor recreational activity, or to give warning of any hazards, conditions, uses, or structures or activities on such premises to persons entering for such purposes. That language would cover the jump, which is the allegedly injurious instrument in this case.
And that's
the
a
hazardous
question of
condition.
law. Can't we decide that as a question of law?
Sure you can. Absolutely. But the thing is, it was not brought up in the brief. I mean, you can take it up if you want to. I certainly argued it in the underlying matter, but the judge decided this case on 50814 alone. If you have no further questions,
Thank you very
Thank you
much,
very much.
Attorney Wright. Rebuttal?
So there was a discussion a moment ago about a chilling effect if there's no immunity in this case. And I would say that the chilling effect would only apply to landowners who are opening their land up for recreational purposes, for their benefit, for their financial gain. And that is not, if that's going to have a chilling effect, those people should be responsible for how they maintain their land. I'm going to go back to the outside playground. this court has found that a playground falls within the scope of RSA 508.14. That was the Dolbear versus Laconia case. So we know that a playground is covered and involves the use of a land. So now if we take a mall owner, he is enticing people to come to the mall because there's this outdoor playground that people can use. He is able to charge higher rents to the individuals who are coming and renting store space because there's this amenity. They know that parents, grandparents, babysitters will come shop and use the playground, and it's directly benefiting everyone and causing a financial benefit for the mall owner and the individual tenants of the mall who are renting the space.
Do you agree that 508.14 and 212.34 go hand in hand and they should be read in congruity?
Well, they are hand in hand. I'm not sure I would agree with that language, because the legislature could have, and we assume by doing two separate statutes, they intended separate purposes. I would agree that there is a lot of overlap between the two of them.
But in discerning what charge means, is there any difference between the two statutes?
So there is a little bit more description in 212.34 about the meaning of the word charge. I think when we look at my underlying arguments about how that should be interpreted in light of what it would do to the premises liability common law as a whole, the same arguments would apply.
How do you distinguish Reed?
How do I distinguish?
Reed.
Oh, Reed, sorry. So first, Reed was a decision by the trial court at the district level, so it has no precedential effect on this court. Two, we don't know from the decision, at least I could not ascertain from the decision, what role the sledding hill might have had in anyone's decision to go there, in their advertising, in their profits. I don't know if it was, I mean, they said it was a sledding hill that the kids went and used, but I don't think we have enough information from that decision alone to know how analogous it is or not to this situation.
Thank you very much, Attorney Zimmerman.
Thank you.
Counsel. The case is submitted.
There we go. You've seen the Supreme Court argument. Now we're going to have the opportunity, if you would like, to ask the attorneys some questions. And if you have any questions, please come to the mic. You should actually form your questions as best as possible about how the attorneys proceeded and their arguments, not necessarily about the facts of the case, but more particularly about how the argument went, what they thought about the argument. And if you, again, the participation is limited to students today, but if there are any questions, please come to the mic and ask your question. In the absence of a question right at the beginning, I maybe start by maybe asking Attorney Goulet-Zimmerman, basically, how did you feel with your argument today?
Well, I'm glad it's done. I'm gonna stand up just because I feel weird sitting while I talk. No, I like the active bench. You might have noticed that we got questions within like the first probably 20 seconds. What I always do when I'm preparing for these is I've got 13 minutes of talking I could do if I had to, but no attorney wants that. You know, you don't want to just be up here talking. So I was glad that the bench was active. I was glad they asked a lot of questions. I see questions, when I look at these, I see questions where I think, okay, that, you know, they're seeing that my way, and then I hear questions where I think, okay, they're not seeing that my way. So it's almost impossible to tell what the questions mean, but I appreciate that the court had a lot of questions. And I say I'm glad it's done just a little bit jokingly, but as the judge mentioned earlier, these things, even for attorneys that have been practicing for a long time, can be a tiny bit nerve-wracking. And when you're all of a sudden in this setting, You know, we're arguing before our highest court in the state, and I've got all of you watching me. So I know I always have this fear. I was telling Michaela this beforehand. My biggest fear is that a judge is going to say to me, what about such and such case? And I'm going to feel like a deer in the headlights and be like, what case? That wasn't in the briefs. I never considered that one. And so that didn't happen. I always consider that a win.
How about you, Attorney Wright?
I am naturally a very fast talker. Sometimes I just get going so fast that I actually write on the top of every page of my notes, speak slowly. And sometimes it works, sometimes it doesn't. But that's one of the things you have trying to control up here is to make sure that you're fluent enough so the judges can hear the argument you're trying to make. And it can be difficult sometimes. I did want to set out a theme that we need to respect the intent of the legislature and what the legislature intended with these statutes. I do think I got that through, and some of the questions allow me to press that point home.
Are there any questions out there? Yes, you need to come to the mic. And if you just state your name and what town you're from, that would be helpful.
I'm Ezra Kate. I go here to Plymouth Regional High School, and I'm from Campton. I was wondering if what the effect of having an audience, a larger audience than normal, on your proceedings had on your arguments.
Normally when you argue the Supreme Court, you probably have an audience of about 10, 15 people, and there are other attorneys waiting their turn. Before I started, I was looking around, so there's a big crowd here. That could be nerve-wracking, but I tell you, once I got to the podium, I was facing the judges, my sole concern was the 5 judges. I was really not aware of the crowd back there. So I think you get the butterflies in your stomach to begin with, but once you start going, you focus on what you need to do.
I would just say I completely agree with that. You know, I start out thinking, I mean, we feel this, the importance of a day like this when the court is doing their roadshow, and we obviously want to put forward our best foot, and we always want to do that when we're in front of the court, obviously, but we also want you to see that and recognize the importance of what's happening today and what they're allowing you to see, and we're really honored to be a part of that process. So that does certainly increase a little bit of the anxiety pre-starting, but I'm the same way. Once I start talking to the court, you know, something really significant would have had to happen out here for me to even notice.
Other questions? Again, just state your name and where you're from.
Hi, I'm Khalil Dakhlia from Plymouth Regional High School, and I'm from Campton. And my question was, how do you engage with, obviously, these 5 different judges, and do each of their individual personalities affect your arguments and the way that you engage with them?
Good question.
That's a hard one. So I think it's important. I'm not sure I'm going to answer it directly, but I'm going to do my best. I try to pick up on themes, like what one of them might ask me, like Justice Donovan asked the question at the beginning about what would you be doing in discovery, or what would you be looking at? And discovery is the process where we get a bunch of information about things and related to the case. And I try to make sure I'm remembering those kind of individual views or questions or where they might be thinking, so I can pull back to that. Or if someone else asks a question that allows me to circle back to that in a positive way, or answer a question I didn't feel like I fully answered before, to do that. So I am doing that. I don't personally come in thinking, I don't know, okay, this person might want to hear it this way, because I am presenting to the full panel, and I don't have a guess ahead of time necessarily on what any individual justice is going to want to hear, so I am more responding to what they're asking as opposed to ahead of time having a perception of what they might want to hear. Does that make sense?
How about you?
I'd just add, you get a sense of where your case may be going by the type of questions you get. You're getting questions that you can give a favorable answer to. That judge has chosen to give you that question to elicit that information. Maybe not for that judge, because they know what the answer is going to be, but they might be trying to convince another judge on the panel who might be sitting on the fence. So you do get a sense of where they're trying to take the case by the questions you get asked.
Hello, I'm Connor Heidenreich. I'm from Plymouth Regional High School right here. And how much of a lawsuit is spent arguing or debating in sessions like this?
Very little.
Oh.
If this case had not been dismissed, because basically the argument is, even with what we've pled, can the case move ahead? There would be a bunch of paper documentation exchanged, a bunch of written questions back and forth to everyone, something called depositions, sworn testimony under oath, a trial, and then appeals. And a lot of cases don't end up being appealed. It depends on the types of cases. The court doesn't have to take every appeal. They do, this was a mandatory appeal, but there are ones they have the choice on. They can just look at it and say, no, we're not going to even accept that appeal. So really, it's a very small number of cases that gets to this point. And here in New Hampshire, this is our only appellate court. So like I practiced in Texas, and there you'd have the trial courts. There were a bunch of middle-level appellate courts, and then the Texas Supreme Court. So you might have, arguments at that level, but even everywhere getting up to the Supreme Court is a very small number of the cases.
Would you like to address the question?
I'd just say, practicing law in the state of New Hampshire, it's a great state to practice law in. We have a judicial system that keeps things moving. If this case had not been dismissed and we were going to a jury trial, it would likely have been in front of a jury within a year of the complaint being filed, usually. Sometimes they get delayed, sometimes there are reasons that it can't get heard, but in that year process, we don't twiddle our thumbs. We're doing the discovery, we're getting all the facts that we need to support our case, or we're trying to investigate the facts that hurt our case. There's disclosures that have to be made of expert witnesses because they have special skill that might be pertinent to the jury. And then we always have mediation as well, where we try to settle these cases. And if that's unsuccessful, then we go to the trial. And usually we get all of that done in a case like this within a year.
I'd say a year and a half.
Thank you. Hello, my name is Leif Eisenbarth. I came here to ask, how do you guys...
Where are you from?
I'm from Plymouth Elementary School. How do you guys form questions on the spot that favor your client?
You mean how we answer questions?
Yeah.
Well, depending on where the judges are trying to lead you. Sometimes they give you a nice open question, you can take it where you want to go. Sometimes they're going to give you a very direct question, and it's one that they've really got the thumb on you, and you really have to give an answer. You perhaps don't want to, but you have an obligation to tell the truth and follow the law in the state of New Hampshire. So sometimes you have to give an answer that might not be helpful to your case, but then you can always explain afterwards and maybe get something that is helpful for your case.
And I think part of what you're asking is, how do you do that on the spot, right? So a lot of that is, you got to know your case really well. I mean, I spent a lot of time, even from the beginning, talking to Caroline, talking to Christopher, what happened, then throughout the process, knowing the case, knowing the cases that the court is likely to ask you about, because you don't want to be, again, sitting here not aware of that. And when you know it, it's no different than if you're arguing with a sibling. If you know the information really good, and someone asks you a hard question, if you're kind of under the spotlight, yeah, that's not a good fact. Or you know that, yeah, I've got a really strong answer for you and I can give it back. But the biggest thing is knowing both the case law and the facts of your case cold before you get here.
If I could just add, if you're asking about preparation, it may be 15 minutes of argument up here, but there's been hours and hours of us getting ready. I have a binder here. Every case that was cited, either brief, I have summarized in here. So if I have to quickly look at it to remind myself what it is, it's there. As you noted, I was reading from statutes. I knew what statutes were going to be important in this case, so I brought them with me so that I can answer questions, use language from those statutes to answer those questions.
Good answer.
My name is Nicholas Ring. I'm from Plymouth Regional High School, and I live in Rumney. And I was wondering how you reconcile the fact that you only have 15 minutes to present your argument, where you might have hours and hours of research to back it up.
That's a great question. And one thing I learned from my mentor, Ken Bouchard, my former partner, you put your best argument on the paper. The paper is what sits in front of a judge long after you've argued. So the brief is the most important thing. And they're going to have that. They can look at your cases. They can look at your argument. They're going to quiz you about your argument here, but they have your brief. What you put on paper is the most important part of the case.
And I would just say that when I create kind of my outline of what I want to say here in front of the court, I always start with what I see are the most important parts and that I want to make sure I get in, and then work down. So again, depending how active the bench is, I'm getting out the most important things quickly, the cases that help me the most quickly, and not burying those in case the question doesn't come up.
Hello, I'm Patrick Like. I go to here, Plymouth Regional High School, and I'm from Thornton. My question for you is, do you feel if both statutes that were brought up today, or at least the two main ones, if they were brought up earlier on in like an earlier session or the original hearing, do you think that the outcome or just what's going on now would have been completely different? And if so, why?
Well, these particular statutes have been tested time and time again. I think in my preparation for my brief, I found 27 New Hampshire Supreme Court cases that either reference 50814 or 21234. So there is going to be some prior decisions that guide you on how the court has interpreted them in the past. And each time it comes up in the Supreme Court, it's a different factual scenario. People are poking at the statute. Does it apply here? And it's the court's job to figure out whether or not it does, and you use the precedent, prior cases, and obviously the intent of the statute to determine the outcome.
And I would say they have come up since the very, very beginning of this case. I mean, it was not a surprise to me that there was a motion early on. I hoped we might do discovery and then have it on summary judgment, but it was not a surprise to me that the issue was raised. And what happened is in the very, very first, down at the trial court level, is Attorney Wright filed a motion saying these statutes apply, therefore the case has to get kicked out. And I responded to that. So it was kind of like it was a smaller version of the same briefing we did here. And then when the trial court agreed with Attorney Wright, I filed the appeal and raised them again. So this is not, the statutes have been part of the case since the very, very beginning.
Thank you.
My name is Patricia Kate. I go to Campton Elementary, and I was wondering what led you to want to become an attorney?
Oh. All right. Well, I am here in front of the Supreme Court, even though they've left, so I feel the need to tell the truth. I wanted to be a jockey. Really love horses, and by the time I was 12, I was too tall already. So my jockey plan went out the door, and but I loved arguing, and I liked helping people. And I thought, I was about 12, I thought, I could become an attorney. It would give me a chance to go argue, I could get paid to argue, and I could help people while I'm doing that. So it's not, that was the basis for my decision. And I am not, if you're worried about what you want to do with your future, I am the exception. There are not a ton of people who decide when they're 12 what they want to do and then go straight through and do it. And are happy with it. But I've always been very, very, very happy with the decision. I've always represented injured people. I love doing it. I love my clients. I love the people I get to meet, and I feel like I make a difference every day.
I enjoy being an advocate. Doing this on behalf of other people gives me what's the self-actualization, I think is the term that Herman Maslow used, but it fulfills me. I used to be a counselor for abused and neglected kids before I became an attorney. And I still look back at that work, and I enjoyed that work very much. But working as an attorney, I get to be a better advocate for people in those situations.
I'm Harrison Jackson from Plymouth Regional High School. I live in Wentworth. How would it affect this case if it was a case of first impression or there was no other case to go off of?
Oh, that's a great question. It's going to depend. If there's no direct case here in New Hampshire with respect to these statutes, there are land use immunity statutes all over the country. So you start looking abroad. If you look for land use statutes in other states that are similar to the one that New Hampshire has, you see if their court has made any decisions on them, and that's what they call persuasive authority. It's not mandatory authority, it's persuasive authority. And you say, look, judges, this is how they decided in Colorado, or look, this is how they decided in New Mexico. You should decide it this way. So you use that persuasive authority to try and create some case law here in New Hampshire with respect to the statute that is at issue.
And I guess at the end of the day, every once in a while, there's someone who's got to be the first on a statute somewhere, and then you come in and you argue, what did the legislature intend? What can we tell from what they intended? What do the words mean? And basically, this court gets to make that decision. It, I guess, makes preparation much easier if you're saying there's no cases I have to worry about, but that would kind of be the process. But Attorney Wright's right. Usually, there's someone somewhere who's done something analogous that we could look at.
Thank you. I'm Christopher Barton. I go to Plymouth Regional High School and I'm from Campton. Based on the past rulings, how can that change the planning and preps for arguments like this where there's prerequisites, and how would that affect everything?
So we look at the past rulings, because if it's a ruling that went the way we don't want, then we need to figure out a way to show the court why that case is different, how you can distinguish that case. If it's a case that's favorable to us, and they're all going to have slightly different facts, right? It's not like we're going to have a prior case that involved Caroline Adams sledding at Max Apples and having this happen. So we look at a favorable case and see what are our facts that are consistent with that case, and how can we show the court that they should follow that same type of ruling and apply that same logic to this case.
No, that was a perfectly adequate answer.
Okay. I think
It's
we
adequate.
have time for one more question.
My name is Piper Burke. I'm from Campton Elementary School and I live in Campton. My question is, what do you have to do for like your research on your arguments? Like, how do you have to do your research?
Well, you just start by looking at case law. It used to be that you had these books you had to look through to find all your cases. Now it's all online. There's something provided by the New Hampshire Bar called Fast Case. And I can go in there and I can put in quotation marks, RSA 508:14, hit the button, and every case that statute has appeared in New Hampshire, the Supreme Court pops up, and I'm able to read them. And that's what I do. I read the cases. I find out which ones hurt my case and which ones help my case. And you argue the ones that help your case and try to explain away the ones that hurt your case.
Great answer. I use the same research tool. There are others, but that's the one I use as well. Sometimes within those cases, they'll also link you out to other cases that might be from other jurisdictions, but then might be helpful for understanding why the court reached a decision that they did. And then we always have to make sure, and the programs will do this, but you have to make sure the case has not been overturned or criticized within this jurisdiction. Because you might hit a case where you're like, this is great. And then when you check the history, you realize that 10 years later, the court overturned the case. So you need to be checking that as well.
Okay, I'm sure you'll agree that both attorneys today did a wonderful job arguing and answering your questions as well, and you should thank them. And now we're going to have a further question and answer, but if you just hold on for a second, we're going to make a little adjustment here. And the Supreme Court justices will be joining us. Again, this is just an admonition that they can't discuss anything about this case or any other case that they might be have before the court or might likely have before the court. So they can't answer political questions. But the questions you have to have for them today are just questions about the process and the procedure. Okay? Everybody understand that? And the same process about coming to the microphone. And again, the law clerks are here to assist people with regard to their questions. One question per person. And you had great questions for the attorneys. You did a super job. So get your, form your thoughts and get your questions ready.
Normally just sit on a chair for.
Yeah?
Yeah, that's typically what I do, just leave them. Just let them know, like, hold from the chair.
Do I have to be on it? Yeah. Okay. Okay.
What do you want? This one or the other side?
Or I'll stand on the side.
Okay, what do you got?
Okay. Good job. Okay. Welcome. This is the New Hampshire Supreme Court. Welcome, justices.
Thank you.
Chief?
Thank you, Your Honor. Good morning, everyone. Still morning. Thanks for being here. We've really been looking forward to this for quite some time. This is a really special day for us when we get to go out on the road and show people of our state what we do. And so now we're ready to hear your questions. But before we do that, I'd like to give the justices a chance to very briefly introduce themselves. And we do everything by hierarchy, most senior to most junior. We have assigned seats, we have assigned parking spaces, so we'll do it that way, turning to the most senior justice, Jim Bassett.
Thanks very much, Chief. My name is Jim Bassett. I've been on the court for 12 years. I live in Canterbury with my wife, Ellen, and we raised 3 kids there. I grew up in Connecticut and went to Dartmouth College and then University of Virginia for law school. Clerked for a judge in Boston and then worked in Boston for a couple of years, and then my wife and I moved up to Canterbury, where we've been for 40-some years. I worked at a law firm in Concord for almost 30 years. Along the way, I got to know Judge Gordon as he and I ran for office back in 1994. I ran for Congress and lost. Senator Gordon, Representative Judge Gordon won, but we've known each other for a long time. Having failed on that effort, I continued as a trial lawyer, and then I was on the planning board in my town for many years and on the Board of Selectmen for many years. And I had the pleasure 22 years ago of arguing as a lawyer on one of these on-the-road cases. So it's near and dear to my heart. And we always love coming out and doing this. So thanks for being here today.
Justice Marconi.
Yes, and I wanted to let you know that the ladies aren't coming in last for any other reason than our seniority placed us here. So 1, 2, 3, 4, 5. I'm Anna Barbara Hans Marconi, grew up in Pennsylvania, but in 1973 my family moved to Bristol, New Hampshire, right next door. Go Newfound Bears. I shouldn't say that. But, and then I went to UNH undergrad, and then I took a detour, thought I wanted to go to law school, but I ended up working in campaign politics. I was a poli-sci major and spent a number of years doing that work, which was great. Segued into some work for a real estate development company, doing planning and zoning and financing. Then it was time to go back to law school. I went out to Chicago, Kent, law school in Chicago that had an environmental law program, which is what I was interested in. They also had a land use program. Came back to New Hampshire and started my practice in Manchester. Went down and worked for a firm in Nashua for about 14 years doing land use. There I picked up a broader, it was a smaller firm, so I picked up a broader array of case types, including family law, probate, trust litigation, you name it, we did it. I came back to Manchester and focused mostly in family and land use cases, and I joined the court 6.5, it'll be 7 years in August.
Thank you. Justice Donovan. Good morning. My name is Patrick Donovan. I grew up in Salem, New Hampshire, and I went to Dartmouth College after I graduated from high school. From there, I went to BC Law School where I met my wife. We live in Wyndham and have raised 4 children there. With respect to my legal career, it began here as a clerk for Justice Thayer back in 1990. I know it's a long time ago, right? And after that, I worked for a big firm in Boston for about 3 years before returning to New Hampshire with the Attorney General's office, where I served in the homicide unit, trying a number of murder cases for the better part of 6 years, and really, really enjoyed it. That's where I learned to be a lawyer and to be a trial lawyer. After that stint, I opened up a law practice in my hometown because I had to get 4 children through college. And I practiced there for almost 20 years. My practice was very general. I did a lot of different things, but primarily trial work in the civil and criminal area. And I've been on the bench for 6 years now. And it's wonderful to be here. Justice Countway.
Good morning, everyone. It's great to be here. I'm Melissa Countway. I'm the newest member of the court. I just started in January of this year, so it's been about 4 months. Prior to joining this court, I was a circuit court judge, and I actually spent a year sitting in the Plymouth District and Family Court right here in town.
Do you recognize anybody in the crowd?
Well, I'm blinded by this light, so honestly, I really can't see anyone, but if you were in the Plymouth District Court in the last few years, don't tell me your name, but at any rate, before joining the circuit court, I was a prosecutor. I also worked in private practice. I worked with Justice Bassett for a few years at the start of my career. My first job as out of law school was as a clerk to the state Supreme Court. So my career has come full circle. I should also mention that I was a middle school math and science teacher before I went to law school at UNC Chapel Hill. I'm from Alton, New Hampshire, and I went to the University of New Hampshire for my undergraduate degree. But it's great to be here, and we look forward to your questions. Chief?
So I've been Chief Justice since March of 2021. Prior to that, I was the Attorney General of New Hampshire for 4 years, beginning in 2017. Prior to that, I practiced at a very large firm with a small, international firm with a small office in Manchester. I was there for about 15 years. I grew up in Hanover, New Hampshire, went to Dartmouth College, took a break between college and law school, worked in the United States Senate, then went to college and law school and began my legal career. I think I am unique on the panel that I still have a daughter, I still have a child in high school. She's 15 years old, about to turn 16, is a 10th grader. So we're thrilled to be here. Justice Countway is now ready to answer all the hard questions.
You have one in high school, don't you?
I have a college sophomore as my youngest.
Close enough.
Yes.
Questions?
So we ask that you tell us your name before you issue your question, in case you actually did appear in front of Judge Countway.
I'm Tegan Hershey. I live in Campton, and my question is, do you guys pre-plan a lot of your questions, or they just happen in the moment?
Well, yes and yes. So yes, we prepare our questions beforehand, and on occasion, based on where the argument is going, sometimes things come up spontaneously. So it's not unusual for that to happen, but we come in with a number of set of questions, and what our goal is to try to narrow the issues that are on appeal if we can, to sort out any factual disputes that might exist, and to address other interpretations that might apply to the case. You know, we're always looking at not necessarily this case, but what is the next case going to look like, and how should we narrow our opinion here to address that future case?
Thank you.
Yeah.
Well, and if I can just add, although it's a nerve-wracking experience for the lawyers, when you think of the process that we go through, we have the briefs, we read the record, we have questions, and this very formal process is the only way we get to talk to the lawyers to get our questions answered. So it's a little, like I said, it can be nerve-wracking, but it's really just a conversation, because we're looking for, to make the best decision that we can make.
I'm Gavin Rail. I go to Plymouth Regional High School, and I'm from Ashland. And my question is, so like before or during a case, how do you form an opinion on going for one side or the other?
Well, as we said, we read the briefs. We have a lot of materials available to us, but we all work separately. I'll read a brief and usually talk to my law clerks about it before the argument. And then, as Justice Donovan said, I have a list of issues that I want to talk to the lawyer about. Often they're duplicative of what my colleagues have. And I'll go into an argument. Usually I have a sense of where I think the case should come out. And more often than not, my view doesn't change, but sort of how the case would be written changes. And I would say maybe 10 to 20% of the time, the oral argument will affect my ultimate vote in the case, but probably half the time it'll affect my way of thinking or how broadly or narrowly we decide to write the decision.
Thank you. Hello.
Yes.
I'm Connor Heidenreich. I'm from Plymouth Regional High School and I live in Plymouth. I was up here before the attorneys.
Just
but-
need to speak into the microphone so we can.
Oh, I'm a little tall, so I got to kind of crush down here. I was here before the attorneys a bit ago, but I got a question for the justices. How much do the rulings of previous cases affect the decisions of a current case or lawsuit that's related?
I'll take that one. So the impact of prior decisions is extremely significant on new decisions and our thinking and analysis. So in general, we think of prior cases as establishing precedent. And so that generally means that those cases have already stated the law of our state. And there's a concept called stare decisis in which, generally we follow our precedent unless there's an extremely strong reason for overruling it. So the existing case law is very significant. Today you heard some questions about cases that were decided in the federal court, and one of the lawyers pointed out to you pointed out to us rather, that was non-precedential. So a decision from the federal court, a district court, or the First Circuit Court of Appeals is not binding on us, but decisions from the United States Supreme Court in interpreting the Constitution are binding. So it's a really important question. That was a good question.
Thank you.
I got a question. My name is Patrick. I'm from Salem. Judge Countway, what has surprised you most about being on this court in the first 4 months?
That's a great way to put me on the spot. Thank you. But I think what was surprising to me is how much the justices actually work together in our discussions of cases. So As Justice Bassett said, our preparation for the cases is completely independent. So we don't really have conversation about cases before they're argued. But then once an argument happens, we'll talk about it. But there are many, many cases that flow through the court that don't get argued orally. So we don't have oral argument. We have to decide which cases we take. Some of them are discretionary appeals, which means it's up to us to decide if we even take a case. And then other cases are mandatory appeals, but whether they get argued in front of the 5 of us or resolved by way of an order is another level of decision making. So the big surprise to me was how much the justices work together in making those smaller decisions. And then the collegiality in terms of the opinions that come out of the court, that was a big uncertain and unknown to me, and it's been refreshing to learn how collegial everyone has been.
I had a question, and that we, before you came out, we had a question and answer session with the attorneys who argued here today, and they spoke about how their approach was towards the court. And I guess the question is, what are your expectations of attorneys who argue before the court?
We are very fortunate that we have a very high level, high competency level bar in New Hampshire. New Hampshire lawyers are singularly, I think, prepared, and that is what we expect. They know their case. They know their case better than we could ever know it. And so we rely on that thoroughness and that preparation so that we can get answers to our questions. And also the attorney can focus our attention to where sort of the rubber meets the road, where the issue gets decided. There are times when I walk into an argument and something the attorney has said refocuses my attention on something that I may have missed. So that deep level of preparation is a big expectation. And also civility, and I will give another plug to the New Hampshire Bar. We are, again, known for our civility, and certainly in an oral argument, yelling, theatrics, drama doesn't do a whole lot. So it's not TV law. It's real people having a real conversation.
I would just add that when I started arguing cases in front of our court 40 years ago, it was a much less interactive experience. I mean, the judges didn't ask as many questions. Often you would need to be prepared to go to oral argument and fill the time yourself, which is a challenge, and you've already written what you think is most important in the briefs. So over time, though, it's very much evolved to what you see now a hot bench, which is the lawyers get up and we give them a minute or two, maybe, before we start asking questions. But as a lawyer, that's what you want, because you've laid out your arguments. You want to know what concerns the judges. You want to be able to answer their questions. And so the way our bench now is, it's an ongoing running conversation. And if you listen to the U.S. Supreme Court arguments, there have been a lot of them in the last week. That's the way it is there too. So it's very much a dialogue with the lawyers. And it was great fun to argue in front of the court. And I think it's one of the best parts of our job, is having that dialogue with the lawyers.
Surely you people aren't all that bashful. If you do have questions, please come to the microphone.
Hi, it's me again. Piper Burke from Camden Elementary School. And the question is, how do you weigh the case in the present versus
What it will mean as president.
what it will mean as president?
I think that's a Judge Conway question.
Well, that's a good challenge. Can you just restate? I didn't exactly hear the first part of your question.
Again.
Hi. How do you weigh getting the current case correct in providing justice versus what the case will mean as precedent? How do you weigh those considerations?
They're both significant factors. Our role is to uphold the Constitution, so it can depend on the type of case that is in front of us, but we know that we're resolving cases for real people, real litigants before us, but we also have a broader duty to the rest of the state and understanding the impact of the case law that we are creating and creating a precedent. So it really is case by case, and I can assure you we look at every angle and every aspect of those competing sometimes factors, and we have to balance that. But again, our overall mission is to uphold our Constitution, the state and federal Constitution. I don't know if anyone wants to add.
One thing that's not really known about what our jobs include is that we're responsible for managing an entire branch of government, that being the judicial branch. There's over 850 employees, and each of us have a number of administrative responsibilities that takes up a lot of our time. For example, Justice Bassett's responsible for an Access to Justice Commission. The chief is responsible for not only managing our budget, but managing personnel. I'm responsible for the rules of the court and the committee that deals with that. And so admissions, Justice HM deals with admissions to the bar, and we're also responsible for the Bar Association too. So there's a lot of things that we do that other than just judging. But for me, and I think everybody would agree with me, the best part of this job is the judging.
Yeah, no one told me about the administrative responsibilities before I took this job. So then you get up and it's like, oh, you're the library judge. I'm like, I'm what? So we have, I'll put in my plug, we have the state's only public law library.
State law library.
State law library. So it was put under our auspices a while ago. It's in our building, and anyone, you have a legal question, you can access the library. Go online. We have Westlaw for people, not lawyers, real people, can use Westlaw online on the library's website. We have remote libraries, so we tried to bring the legal materials out into the community, and I think we're going to have one here in Plymouth. We have Derry, Littleton, Portsmouth, Dover. So these resources, because the majority of people going to court are self-represented, they don't have lawyers. These resources are very important for people who are going into court so that they know what they're doing, how to do it, and have a little backup. So no one told me, but I do love being the library judge.
Hi, I'm Khalil Dakhlia from Plymouth Regional High School, and I live in Campton. I just had a question for all of you. How have you, as lawyers and justices, seen the court change over the years, and has that had any significant impact on the decisions that are made?
You've been here the longest.
Well, I alluded earlier to a difference, I think, in terms of how the court interacts with lawyers and arguing, and how that's changed in the 40 years that I've been involved. And I do think one thing that shifts over time that I think does have an impact is when I got on the court 12 years ago, I was the only justice on the court who had not been a trial judge before that. So I sort of pitched to the governor at that time, you need somebody like me who's been in trials and who has had to argue in front of the court to be on it. But I think it's also equally important to have the trial judge perspective. And so in the time that I've been here, that's evolved. So now Justice Countway is the only one of us that served for many years as a trial judge. So I think that's a mix that flows back and forth, but having both of those perspectives on the court, I think, is extremely important.
Anyone else?
I would add, I think this court is very willing to address and react to things that are going outside the four walls of our courthouse. Things like finding people to represent indigent defendants that are that are being charged with crimes that might involve incarceration and doing things that I think other courts were reluctant to do for a number of different reasons.
And one last thing, I know we have 2 other questions in line, but if you think about the On the Road program, the first one was in 2002. That was the year I clerked. And if you look in your program, the first one was at St. A's, and then the second one was the same year at Dover High School. And I remember going as a clerk to the Dover On the Road. But that shows a remarkable shift to openness and transparency. It would be extremely rare before that to see the justices really in public, let alone doing an event like this. So that is a big change.
Right, and we focused a lot on civics and civics education so that people understand the role of the courts and what the courts can and can't do. And so that's another outward-facing activity that we've taken on.
Hi, my name is Will Hicking. I'm a junior at Plymouth State University, and I also went to Dover High School, and I'm from Dover, New Hampshire. My question is, so when you're in court and you hear both arguments and you have this kind of preconceived idea of what both parties are arguing, and that you kind of, in your mind, have an answer for, have an idea of, who you side with the most, how difficult is it to continue to ask tough questions?
Well, I'd just say, I think I actually ask harder questions of the lawyer who's presenting the side that I'm likely or inclined to agree with, because I want to kind of push the edge and see whether the direction I'm going is actually going to hold up, and can the lawyer push back. So I think the fact that you're inclined in a certain way might actually energize you in terms, because you don't want to write it wrong and you want to get the boundaries of the case just right. So I think you want to take that into asking questions of both lawyers, but you're not soft on the side that you're inclined to agree with.
Yeah, I would say really important skill to develop, which is one that practicing lawyers don't have. They're advocates for a side. But the skill that we need to develop is to always have an open mind. And even where you go into an argument or you're working on a case where you think you may know where the case will end up, you have to have that discipline of an open mind. And speaking personally, I have long lost track of how many times my mind has changed over the course of working on cases. And it's just, it happens. It's an iterative process. That means we just go step by step by step, and at each step there may or may not be a different revelation, a different look at the facts and the law, and it's just really, really important throughout the process to keep an open mind.
Right, the case is not over once the argument's over. It has a life that continues.
And we have a lot of people at different stages of the case in the court, our law clerks, and then whose responsibility is to come to us and say, I think that's not right, or they're pushing back. We have a lot of checks in the system, and the case is not over till it's over. I mean, we've had times where we've drafted something, and then after it's been circulated to the judges, it's like, no, we can't do that. So I think no system is perfect, but we have a lot of checks in the system, and we try to get input from as many people as we can, because our responsibility is to get it right.
You can't have a big ego. People tell you you're wrong. Hey, I have to be able to look at it.
Hi, I'm Ezra Kate. I am in Plymouth Regional High School, and I'm from Campton. And I was wondering, to what extent does perceived public opinion affect the way that you rule a trial?
Good question. It doesn't. It can't. That's simple.
That's an interesting question, but that is the answer. We have to focus. A lot of our cases have to do, as you saw today, with interpreting statutes. So the legislature passes a statute, we have to figure out what it means. That doesn't depend on public opinion. It depends on a process we go through to figure out what the legislature intended with that particular statute. So you heard a lot today about what was the legislative intent, what were they trying to move forward and achieve. And so we are constrained. We're either interpreting statutes, we're applying the Constitution, or we're interpreting contracts. And again, it's a process that is unaffected by public opinion.
We also have a code of judicial conduct that governs our behavior, and it's a relatively strict code. And there's a judicial conduct committee that oversees and enforces the code of conduct. But part of the conduct code is that we have to be fair and impartial and not subject to opinion, popular opinion.
Right, we say this all the time. To the extent that you're looking for somebody to make a policy decision, that's for the legislature. It's not up to us to make that policy decision. Instead, we interpret statutes plainly in order to determine what was the legislative intent here.
There was, I think you've already addressed it somewhat, but you've heard the arguments today, you've read the briefs. How are you now going about resolving or coming to a decision on the case?
Well, we discussed it immediately after the argument, and Justice Countway, because she's the most junior, was responsible for taking notes of our positions and where we might want to land. And so at this point in time, the case has already been assigned to somebody, to one of the justices. That justice will take it in chambers and follow the straw vote and read all the cases and that are cited in the briefs and do our own research and to determine what's the right result.
And in terms of that process, the judge who's assigned to the case, that is completely random. We literally pick case names out of a picture. So we have somebody that writes out the case name on a little card, and then we randomly pick from the picture to figure out.
Very high tech.
Yeah.
Extremely high tech.
Paid a lot of money for that process.
Yeah, I would just add that today is unusual because it's one argument, but normally, for example, we have 2 days of arguments set for the middle of May, and each of those days is 6 or 7 arguments, separate cases in front of the court, and then we have a additional set of cases that we will discuss but aren't going to be argued in front of us. And so our normal process is we begin at 9:30 and we hear 2 cases, so that takes an hour, and then we break and we conference those 2 cases, and then we hear another 2 cases, and then we conference them during lunch, and then we hear another 2 cases. And so that's how we do it. Recency, so it's right in, we come right off the bench and do that, which is a contrast to what the U.S. Supreme Court does. They'll hear arguments normally on like a Monday, Tuesday, Wednesday, and then they conference their cases on a Friday.
Hello, my name is Dylan Renner. I'm a junior at Plymouth State University, and I'm from Phillipsburg, New Jersey. What advice would you give to the younger audience out there who want to pursue law?
Take a break between college and law school. Doesn't have to be a long one, but take a break, and take a break before college if you want to. But get out and do something so you have some comparable experience when you enter, or some kind of contrasting even experience when you enter law school.
So when you say take a break, you mean working, right? There are parents out there.
Yeah, working,
Get a job.
working. Save some money before you go. Go where it's affordable. Don't rack up big debt. And take a break working before you go back to law school.
Also, New Hampshire needs lawyers, so part of our, one of my administrative duties includes encouraging a pipeline of young people to come to New Hampshire to be lawyers. So if you're in high school, please think about it. If you're in college, please think about it. The court has internships, we have clerkships, We have other volunteer activities, and if the court system isn't interesting to you, there are a lot of opportunities for people that are in law school or thinking about law school. So I really recommend volunteering and trying out some of the different types of activities that lawyers can do, ranging from criminal law, and you could be a public defender or work with the public defenders if you're interested in prosecution. Even if you think in your career that's not what you want to do, it's worth it to try some of the different activities that are out there.
And consider UNH Law. It's a wonderful school. It's very reasonable. And, you know, you'll get a lot of opportunities if you do go there to do exactly what Justice Cantway is talking about, getting internships, getting in opportunities to actually practice before you graduate.
They have a 3-in-3 program, which I'm sure you all know about, but 6 years, you then develop both degrees. Now, that goes counter to my take a break advice, so you're going to have to weigh that.
I don't see any other questions. Do you want to make any closing remarks?
I will just say, if you're bored in the middle of the night, can't sleep, our arguments are on our website also. So you can dial in and watch old arguments.
And fall asleep.
And fall asleep. It's great.
Before the chief has the last word, I just want to say that last week with my grandchildren, I watched Granite State Challenge, and your team is doing great, and I think I recognize you with the hair, so very impressive, and good luck in the semifinals.
Go Bobcats. Just picking up on the last question, it's so energizing for us to be before an audience like you, engaged young people who have an obvious interest in the law. And I encourage all of you to think about a career in the law. At the end of the day, our democracy is founded on the rule of law, and all lawyers, whatever they do, upholds those ideals and those principles. And we need good people, young people coming into our profession. So thank you very much for being here. Just a few thank yous on behalf of the court. I want to thank Principal Parsons. I don't know if he's still here. Acknowledge your 34 years of service to Plymouth Regional High School, and that's really impressive. And best wishes and thanks. I really want to thank you and your entire team for being such great hosts today. We got a chance to meet civics teacher, Mr. Casarino. It's obvious you did a great job in preparing your students for today's program. From Plymouth State University, we have Professor of Criminal Justice Mark Fischler here, and Aurora was here too. Want to thank Fresh Picks, Randall Lampron. Took great care of us, and we look forward to visiting with the Culinary 2 students. Want to thank law enforcement, State Police, Plymouth PD, our own court security team, and everyone from the New Hampshire Supreme Court who came up and made today happen. Leading the effort was our communications manager, Harris. Thanks to Pemmy Baker TV, we were able to do something we haven't done before, which is take their stream and shoot it out through our system, which was really great. So everyone across the state got to share and see what happened today. But finally, I want to thank you again, our audience. I mentioned I have a 15-year-old. I have some sensitivity to how being without a phone for this long a time can be a bit of a challenge, but I'm really, we're all grateful and so impressed by your engagement and your interest in what we do. And on behalf of the Supreme Court, New Hampshire Supreme Court, thank you very, very much.
With that, I want to thank the lawyers who argued today. Thank you very much for coming up and presenting your case.